Welcome to this special edition Pepper podcast focused on the current state of marketplace lending. We are recording this podcast with senior members of Pepper's marketplace lending practice before they head off to the Marketplace Lending Plus Investing Conference later in September of 2016 in New York City. Joining me today are Pepper partners Julie Corelli, Greg Novak, and Rick Ekman. Everyone, welcome.
Thanks, Brian.
Thank you, Brian. Thanks, Brian.
Rick, let's start with you because you were speaking at the conference this year on the panel entitled Hot Legal Issues Facing Today's Marketplace Investors. The panel will focus on key legal and regulatory developments in marketplace lending and investing, including Madden, CFPB, and state initiatives. Can you give our podcast listeners a preview of what you're going to talk about?
Thanks, Brian. Yes, we have a great panel, and we're going to focus on at least four of the hot legal issues which are facing investors in marketplace loans today. You mentioned the Madden case, which is a case that was appealed to the Supreme Court. They denied cert, and so now it is currently on remand to the U.S. District Court in New York to focus on the issue of choice of law. But we are still stuck with the problem that Madden provides to this industry, and it will be a continuing effort, I think, for investors to navigate around that. We're also going to talk about a recent case involving the CFPB and cash call. That case is involved the true lender theory, and really was not a good result for the industry, because it found that cash call, a servicer, was in fact the true lender and not the tribal affiliate that was allegedly the lender in the case. So that case is quite troubling, but I think that there are some ways to distinguish it with respect to the marketplace lending industry, and we're going to talk about that. The FDIC is also active in that they provided a proposed guidance last month on the issue of what activities a bank needs to undertake when it is originating loans for third parties, i.e. marketplace lenders or platforms. And they came out with a extensive list of steps that banks have to take to underwrite these particular types of loans, to deal with security issues, compliance, the whole panoply of issues. And the bottom line is that a bank that's originating loans for a marketplace lender really has to treat that loan as if it's going to be kept on its balance sheet, which is probably going to raise costs, for that particular structure. And finally, the CFPB is always lurking in the background. This summer they announced that they're going to start taking complaints from marketplace lenders on their complaint portal, and they have a initiative underway to start the process of collecting data from small business lenders, which would include marketplace lenders. And so clearly the CFPB has a big interest in this area. They're hiring a director to deal with marketplace lending issues, and so more to come on the CFPB, but they are certainly the 800-pound gorilla in the room and have to be watched very carefully.
Hey, Rick, this is Greg. What exactly does it mean when you're talking about extending the complaint portal to marketplace lenders? How would that work out for our investors or the borrowers, for that matter? And is the CFPB focused on the investors, or is that the bailiwick of the SEC, and CFPB is really only focused on the borrowers of the underlying loans?
I think that's a good question, Greg. The complaint portal has been set up by the CFPB to provide a Yelp type of experience for those in the financial services industry, so that if you have a complaint with respect to your mortgage or with a debt collector or your credit card, you can actually log into their website and lodge a complaint against that particular lender, and then the lender has had to register with the CFPB, and then they use that as part of their enforcement policy to determine what's happening in particular industries and who they should be paying attention to in terms of any potential violations of federal or state law. So what they did was, with respect to the marketplace lending industry, is really just open that portal up to borrowers that obtain loans from marketplace platforms. So if you have a lending club loan, you could actually log in. You had a problem that wasn't resolved by lending club, you could log into their portal and lodge a complaint, and they would have to respond to you. So I don't think it really affects investors. I think that's really the pet bailiwick of the SEC, but it's something that investors should be keenly aware about, because if you have a lot of complaints with respect to a portfolio of loans that you have interest in, then that could presage problems down the road from a compliance standpoint.
So, Rick, if we get the question, which we frequently do, whether that is discoverable or known in a due diligence process from the investor side, that's one question. And second, is it known to the lender who gets the CFPB inquiry after something comes across the portal from a borrower complainant? Do they know who the complainant is? Is it public information?
Yes, it has to be, because they have to know who the complainer is to be able to investigate what the problem is that they're raising. So, those complaints are not public, to the general public, but they are certainly known to the CFPB and to the lender or other provider, of whatever financial services we're talking about.
So an investor gets the information through due diligence inquiries of the lender, not by
Correct.
able to go onto the portal and see what's happening.
You can go onto the portal and see, what kinds of complaints are being filed. So it is possible that you could make that as part of your due diligence process, both talking to the lender itself as well as doing your own due diligence with respect to the complaint portal itself.
Do we have any statistics on how many complaints have been lodged since the portal was opened?
Oh yeah, those are widely available, and what they do is they categorize the complaints by industry. So the largest complaints are being filed with respect to the debt collection industry, for instance, and they can tell you the number of complaints that have been lodged. They even can tell you what state they come from, and so they oftentimes will highlight a particular state or series of states as to what type of complaint is prevalent, or most prevalent in that state. But it covers really the whole gamut of the CFP's jurisdiction. So basically, any type of consumer credit, would be covered, or any service that would be provided in connection with consumer credit, such as things like debt collection or credit reporting are also big areas of complaints.
So the message here is that the CFPB is here to stay. They're going to be focusing on the input side of the equation, right? The loans themselves and whether or not we have a risk. So if you look at it from the investor's point of view, is this just another disclosure item where we need to beef up the disclosure in the borrower payment dependent notes and make sure investors are aware that if they buy these off of a platform, there may be this risk that will erode the value of the loan that they're purchasing on the platform? And more importantly, if you're dealing with a fund or some other commingled investment that's investing in these loans, that disclosure needs to be beefed up? Is that enough, just disclosing the risk to investors?
Well, I'm not sure there's direct risk to the investors. I think it's indirect risk in the sense that you want to know that just because somebody makes a complaint doesn't mean that it won't get resolved. I mean, it could be just a question that somebody has about a product that but the whole key is when I advise clients in this area is you really need to have a very robust complaint resolution mechanism to prevent people from actually lodging a complaint with the CFPB, because that's typically the only time people are going to do that. that is when they haven't gotten satisfaction from their servicer or from the lender directly. So it just is in my mind, sort of a warning sign that that investors need to be aware of, that perhaps their compliance, the compliance program of the lender or servicer that that they are invested with, needs to be beefed up.
Thanks, everyone. Next question. Greg, you hosted a popular marketplace lending meetup in Pepper's New York office a few weeks ago with Lending Times, and you had a number of players in the industry on your panel, including Rick. One of the topics was, how did the fact that Madden v. Midland will not be heard by the Supreme Court affect regions outside of New York, Vermont, and Connecticut, as well as the effect on borrowers in New York, Vermont, and Connecticut? Can you share some thoughts with our listeners?
Sure, Brian. The fact that the Supreme Court chose not to hear the case essentially leaves us with the case on remand, which is back to the Second Circuit, back to the District Court, to make the determination of whether New York law or Delaware law controls. And if New York law controls, whether or not New York law itself has a provision in it that would enable the investor or the holder of the loan to rely on the valid when issued doctrine, so that the whole crux of the Madden case being whether or not the holder of the loan is entitled to rely on the valid when issued doctrine. I think the upshot of the panel was that there is a wait-and-see approach, that people have rejiggered their loan origination activity to fall within the usury rules in those three states at a minimum, and that outside people are focused on the true lender issue that is sort of a close cousin to Madden, because the real question is, who is the lender on the loan? If it's a bank, then you get the interest rate, and if the valid when issued doctrine applies, then that interest rate carries over forever. And so it's two sides, or a step one and a step two of the issue. And I think the panel said they're not making loans that are in excess of the state usury rates in those three states, and they're getting representations that the loans that they are purchasing as investors have been properly seasoned, and that they're beefing up their ability to unwind loan purchases to the extent that that's possible.
Julie, let's turn to you. Are there other cases out there that the industry is waiting to see how the courts rule? Bethune v. Lending Club, for example, or any others that you think of?
I think there was a couple that we're watching, but they're not as significant as the Madden and cash call cases. A lot of them deal with who is, in fact, the true lender. I'll talk quickly about one and then turn it back to Rick on the cash call case. But the one I'd mention is the Kane versus Think Finance, where the Pennsylvania Attorney General, Kathleen Kane, brought a case against Think Finance saying it was improperly making loans in Pennsylvania and wasn't registered to do so. Think Finance is a payday type lender. A lender might put the rabbit in the hat. Unfortunately, the case that, as it's made public to date, was just an opinion on a motion to dismiss, which meant that you took all of the Attorney General's arguments at face value as if they were true and said, was there enough there to make a case against Think Finance if everything was true? And the way it was argued, the answer was yes. So we are watching where that one comes out, but nothing new has developed on it at this point in time. For the cash call case, I think we heard Rick talk a little bit about it before, but Rick, maybe you can go into some more of the detail behind that case and why it's one to watch and how it's distinguishable from a lot of the other situations out there.
Sure, thanks, Julie. Yeah, the cash call is a online lender. I actually have done several deals with them with some of my banking clients a number of years ago. And their struggle has been to be able to charge, higher interest rates than are permitted by many state laws. And so they've done this through bank partnerships in the past. And this case involved them partnering with a tribal affiliated lender in South Dakota, and we have had a lot of experience in setting up those types of programs. In fact, we set up the Plain Green relationship with Think Finance, which is involved in the Pennsylvania litigation. But the difference in the cash call case is that the person, Butch Webb, who is a member of an Indian tribe, and just set up a South Dakota limited liability company to be the lender. And the loan activities, were taking place on the reservation, but the entity was not an arm of the tribe. It wasn't a tribal limited liability company, which is a key distinction under very settled, case law, where the arm of the tribe has the same sovereign immunity that an Indian tribe enjoys under our United States Constitution. So that was a key distinction, and I think hurt cash call in terms of trying to argue any of the things that you'll get by being an arm of the tribe. But the real problem, and this was in my mind a fact pattern that existed 4 or 5 years ago, but has been eclipsed by the way that these kinds of relationships are set up today. In that cash call really did everything in terms of the loan. They put money at the lender to cover the 2 days of proceeds, or interest or principal, if you will. The principal of the loan. And so it really wasn't the tribal lender's loan. It was really viewed as the cash call loan because it was their money that that funded the loan. It was only held by the bank for 2 days. All of the underwriting was done really by cash call on a server located at Cash Call's headquarters in California, so they didn't have the server, on the reservation. And there were just very little activity, by the tribe in terms of either making this loan or trying to collect the loan, and then the loan was sold, 2 days after it was made. So it had all the indicia of, what courts like to view as who has the predominant economic interest in this loan. And there was a case a number of years ago involving cash call that the West Virginia Supreme Court ruled upon, and they found the same situation. This one involved a bank as the lender, but there was the same type of program, where cash call had the predominant economic interest in the loan and did all of the underwriting and actually indemnified the lender for any problems that would arise. And so the court in California that dealt with this case involved that the CFPB brought against cash call really mirrored a lot of what the West Virginia court found in terms of predominant economic interest. And so they also looked at the issue of choice of law, and they used the restatement 187B2, I think it is, of the restatement of conflicts of laws to analyze whether the tribal choice of law was valid or not. And the first prong of that is whether or not the law chosen has a substantial relationship to the parties. And they found, because of this fact that cash call was, in fact, the true lender, that there was no substantial relationship. So they failed on that test, and then they also failed on the test of whether the forum state where the borrower resided had a fundamental public policy that would defeat the choice of law. And they also found in 16 states that they had a quote-unquote public policy to make loans that were made above their usury rate would be void. And so they imputed a public policy, in that. Although some states like Kentucky actually indicate in their usury statute that it's the public policy of the state, that our interest rate is X, and that type of thing. But in any event, so there are really two ways that they attack this, on the true lender basis and also on the choice of law. And so it'll be interesting to see, what happens to the case. It's going to no doubt be appealed to the Ninth Circuit. In terms of the impact on the marketplace lending industry, I think you have to look at this is a very factually involved case. always said, I've written on the subject and said repeatedly that the cash call cases, when you read them, are a checklist of what not to do.
So let's go into that, Rick. What exactly should they not do?
Well, for one thing, you want to have an independent source of funding for these loans. You do not want the servicer who's buying the loans to also be providing the funds to make the loans. That's a very, very important fact.
So let's say a bank has deposits. That's its independent source of funding, right?
Mm-hmm.
But what about somebody who's a platform lender? They have a state lending license, or not, and they're either making commercial loans or they're under one of the limits so that they don't need a state lending license. And they go out and they raise capital, or they have a warehouse line with a bank, or they have some other source of funding. That's still viewed as a balance sheet loan on behalf of the lender, is it not? Or are they going to push it all the way back to whoever provides the capital in the first instance?
No, I think that's a different type of situation. A bank, as you indicated, can get funds from many different sources. It can get it from depositors. It can get it from the marketplace, in terms of subordinated debt. It can get it from equity. So there are, a lot of ways for banks to get it. But the point is that you don't want to have an agreement, with the entity that's buying your loans, that says that, as a requirement for doing this, you have to give us enough money to have on deposit, for us to, make 2 days worth of loans, and that we can increase that depending upon the volume. I mean, that's just, something that the court really, really focused on. So I think, you need to have independent, sources of funding that are not dedicated, to funding these loans if you are, the entity that's actually going to be purchasing them.
Now, as you can fund in advance or you can fund after the fact. So if I have a forward flow agreement that says I'll buy every loan that you make that's within the following guardrails, is that going to be an issue?
No, I don't think that's an issue, because that's a fairly typical kind of bank relationship. I mean, you have, many kinds of forward flow agreements involving all kinds of consumer assets, whether it's auto loans or home equity loans or mortgages or whatever, that meet certain minimum criteria that says if you make a loan that meets this criteria, then we will consider buying it. So I think that's a standard banking practice, and that doesn't bother me. But what I think the court focused on, was the fact that the underwriting that was done primarily by cash call in this case, and they just wholesale adopted the underwriting criteria of cash call. And I think that's a subtle distinction, but it's important that each one of these lenders actually have a robust underwriting process. In fact, that's one of the things that the FDIC said in its proposed guidance. So I think all of the things, if you follow the FDIC's proposed guidance, it's going to help you, resist these attacks that somehow, that the bank is not the true lender. In addition, I think that the 2-day hold is something that has always worried me, and I think I know there's seasoning for tax purposes, which I think a lot of people have used, but the longer the better. And one of the ways that I think the court could get comfortable with that is that the bank should be holding the loan long enough so that there could be a default, so that if you would held it past the first payment date would be sort of the ideal situation. And the other thing that's important is that the bank has skin in the game, and that term was used by the court. And so you have to figure out ways that the bank is actually has a continuing interest in the performance of the loan, whether its compensation is based upon that ultimate performance of that loan, which is what Lending Club did when they amended their agreement with WebBank this spring. I think that was one way to kind of look at the true lender issue, and also Madden by having a continued interest in the loan. But it's something that if you look at each one of these factors, I mean, indemnification was another one. Now there's an interesting juxtaposition position between, or tension, if you will, because the FDIC, when it comes to vendors, wants vendors to indemnify the bank for any problems that arise in the relationship. But I think the difference is that it has to be focused on the indemnification of the actions of the entity, and so you're not indemnifying the bank for their problems, in terms of compliance issues or what somebody said on the phone to a borrower. I mean, that's anything that's within the bank's control, in my mind, shouldn't be indemnified by the servicer or the person buying the loan. It's only the issues or the things that are within their particular control that they should be indemnified for.
But hold on a second, Rick. I mean, that's a normal commercial practice where, business people like to have their risks mitigated. It's no different than buying a swap to offload interest rate risk. Why would the CFPB or any other court or regulator think that if someone has acted rationally and conservatively to lay off risk, that somehow, some way, that means they're not doing their job and they're not the actual lender? I mean, isn't that just a bridge too far for the courts to go there, or were they just grasping at straws, looking for a way to justify a result they wanted?
Isn't it just a factor, though, in the conclusion about true lender? It's just one of the factors.
Exactly.
And if the bank isn't responsible for its own actions, which we all think banks should be, then it's taken away. You take away the accountability through the indemnification, and that would be a bad factor. Not controlling, though, in my understanding, and but it would not.
It's what they call, what the court called totality of the circumstances. And just as a sidelight, I mean, I think the predominant economic interest test is wrong, and it's never really been adequately argued, in my mind, in any of these cases, because if you think about any kind of normal banking transaction, when they are immediately selling off the economics of a loan they make, or a credit card loan that is made, it's automatically sold into a securitization. They don't have the predominant economic interest in that case. It's the entity that's that's buying the receivable and then issuing debt to outside investors that has the predominant economic interest. All the bank is doing is servicing the asset. So that can't be the right answer in terms of this area. In my mind, it only applies to high-interest loans. That's the only time the predominant economic interest test has ever been applied by any court in the United States. It's only been applied to payday loans or high-interest loans, like in the cash call case. And the other cases, which what I view as the better view or the prevailing view, I'm viewing Crispin and the pay me later case or bill me later case in Utah that was just decided, use a completely different test, which is a bright line test, which looks at who made the loan, who funded the loan, what's the name on the paper, and they don't go behind the loan to see what happens to it. And that's a bright line test and should be the correct test.
So you have these true lender series of cases, and you have the state usury series of cases. We skipped over Bethune a little bit in the beginning on purpose. Going back to that and the impact of it on Madden, now that the Supreme Court has said that Madden is not going to is going back to the Second Circuit. Bethune, of course, is in the Second Circuit, but it's a class that may involve loans in other states. So, Greg, maybe you can talk about the impact that if that case goes forward out of the Second Circuit and is class certified and involves all these other states, what it means for state usury laws. Or maybe, Rick, whichever one of you wants to take that question.
Yeah, I think that case is early, is pretty early in the process. I mean, you have class certification that I don't think has been determined yet. So that these cases take forever to wend their way through the courts. There's also a case called the Ubaldi case, Ubaldi, that's pending. It has been pending in California for, I think, about 4 years. I've been following it, and it was a big fight on class certification. I think last December, class certification was finally granted, and that involves Sally Mae, which has a similar they partner up with banks that actually make the student loan and then buy the student loan, if it meets certain criteria. And so that case involves actually a late charge. I mean, of all things, that the late charge that was charged by the bank is not permitted in the state of California. So that's another case to kind of keep an eye on.
And of course, there's securitizations that have occurred in at least Prosper and Common Bond, where there's implications, maybe not so much for Common Bond because their student loans are at interest rates which tend to be, at least and reportedly are, below usury rates in the states that their students borrow in. But there's an impact on securitizations, and there's an impact on the business model. You started to see Lending Club change its business model a little bit, arguably, in their view, not because of Madden or Bethune, but because of risk mitigation and spreading the risk. But the securitization market has been slow to take off, it seems, maybe because of those things.
Well, actually, I think you mentioned the securitization market. There's a couple of issues that have come up in securitization that I think are causing people to get cold feet. Obviously, Madden and Bethune and Cash Call, all of these cases deal with the input, what is coming into the pot, and therefore is available for further distribution. The problem that you have now is there is a lot of fervor, or fluff, I guess is the better word, about are the loans that are now being potentially put into other pools for securitization purposes securities. There is some ancient Supreme Court dicta and doctrine that whole loans are not securities for purposes of the 1933 and the 1934 Act, but that leaves the Investment Company Act of 1940 completely open, and the SEC demanded that recent registrants for closed-end funds make the representation that the whole loans that are in the portfolios are in fact securities. Now, if you think that through, if you're going to run a closed-end fund, you want to avoid taxes. In order to avoid taxes, the Internal Revenue Code requires a registered investment company, including closed-end funds, to be invested in securities and to meet a diversification test and an income test, with 90% of its income being derived from securities. So you're not even in the right ballpark if these funds are not invested in securities. So I think the SEC was merely requiring these funds to acknowledge what they had been representing to their investors for purposes of the investment. But the reason why I raise this here is if, in fact, this push by the SEC extends beyond the registered fund context, and now marketplace loans, as they get transferred from the originator through a platform to an investor, if they are in fact securities, whole loans are in fact securities, do they need to be issued pursuant to a private placement memorandum? Is there now issuer liability? Who is the issuer? Is the issuer the platform, or is the issuer the underlying borrower? Ordinarily on a note, the borrower is the issuer, but if these things go through a borrower payment-dependent note back-to-back arrangement, well, no, now the platform is the issuer and you have concentration risk. So there are a whole host of issues that come from the determination that these are in fact securities, and it materially impacts the securitization market, because now the transfer from whoever holds them, whether it's a fund or a platform, into the securitization vehicle is the sale of a security and the placement of a security. And if the manager's on both sides of that, then he's got an Investment Advisor Act issue under Section 2063. It's a principal trade. So you need consent then from independent parties. So there are a number of collateral consequences to that determination that put the securitization market on edge, because if anything, securitization market likes certainty of result and predictability, since their waterfalls are designed to be very, very tight within very defined guardrails, especially if they're trying to get a rating for the senior classes that come out of the securitization. The impact of the Madden and other cases that we've talked about, plus this latest twist with whether or not the whole loans are securities have caused a number of my clients to say, well, we're going to take a wait-and-see approach. We're not going to push the securitization at this point simply because we don't know and we can't get clean opinions, and therefore we need to see how this plays out before we do more securitizations. That has also had a collateral impact on the formation of new funds and further on investors investing in those funds who are now saying, well, will I get the benefit of my bargain? Disclosure helps to protect the issuer and the promoter, but may not be enough to get investors comfortable, because ultimately that's a buyer beware concept. If you tell them there's a risk, then they internalize that risk and say, well, maybe I should wait and not make my purchase right now because the only defense I have is not making the purchase. So we're seeing the collateral impact of this uncertainty find its way all the way through, with the end result that investors are looking elsewhere for yield and not necessarily willing to take a risk on these instruments.
And taking that a little bit further, even in the discussion of securities, there's so much creativity in what gets financed these days. Applying that question of whether something is a security, which for lawyers often was something we thought would be easy to do, becomes more and more difficult. But when you have a question of whether something's a security and you have a platform that is matching investor and seller, if you will, or borrower with a loan, you have broker-dealer implications as well. And that is another area of quandary, it seems, in the marketplace lending space, whether somebody needs to be registered as a broker-dealer. And if you are effecting transactions in securities, I think our advice would always be then you need to be registered as a broker-dealer if you are being compensated for effecting those transactions. There's been some uptake in that by a lot of people that want to take a wait-and-see approach as to where the SEC comes out on it. The SEC recently announced that it was going to target the broker-dealer issue in funds, and that's not new news. They've been saying that for quite some time, but they again announced it recently, just earlier this week, that was going to be an area of focus for them. So that's another chilling aspect on the regulatory front. I know, Greg, you spend a lot of time working with people on that issue. Want to add and elaborate on that point?
Sure. I think the broker-dealer issue is a symptom as opposed to a cause. If, in fact, these are securities, then the expectation is that only a registered broker-dealer can take a fee for the transfer of ownership of a security. That's pretty well-established law. It's Section 15A of the 1934 Act, and that is our general advice. But even if there's a question of whether or not it's security, the real question is, what's the reasonable expectation of the investor? Is it an investment contract, which under the 33 and 34 Acts would be deemed to be a security? Well, you can't, turn a blind eye and say, well, it's not a security for purposes of 33 Act. If, in fact, the reasonable expectation of the investor is they're putting money at risk in a platform who's creating this instrument, it's then being transferred into an investment account where I'm paying my money for that investment and compensating someone to put it all together. So I think in the same way that the private equity and hedge fund industries have begrudgingly started to embrace regulation and recognize that maybe in certain instances they do need a registered broker-dealer to engage in some of the activity that they're doing, I think it will come, but it'll come slowly to the marketplace lending industry that certain activities do require a broker-dealer. Now, a secondary market where you're placing these investments, certainly if they're fractionalized interests, these are registered securities, you need a broker-dealer. There's no question about that. But in terms of whole loans, where you're moving them from one platform to another, the real question is, do you need to be a broker-dealer to do that? If they're whole loans are securities, clearly you do. An interesting analog to this, not directly on point, but a nice analog, is the way the industry treats the movement of bank loans. Bank loans are one of those instances where the courts have in fact said that they are not securities, but dealers will not sell you a bank loan unless you are a QUIB, a qualified institutional buyer, which means an entity having more than $100 million under management. And that is essentially the industry saying we're going to be very conservative and we're not going to allow this transfer to happen unless you meet the requirements of the most gold-plated exemption from registration. And with the industry's dealers taking that position, I think when you're dealing with these much smaller loans, to try to say that they're not securities or that they don't require a broker-dealer is probably a fool's errand. I think the winds are blowing in that direction that the regulators will get there. They're not all there yet. The SEC, I think, may be there. They just haven't announced it. But it's going to be a matter of time. And again, this is one of those instances where we're seeing law being made through the enforcement process as opposed to the real rulemaking process. And that is, of course, always challenging.
I think as one final comment, Greg, I would add to what you're focusing on as quandaries in the industry is the growing use of arbitration, or the trying to grow the use of arbitration, which we're seeing, and the pushback we see from regulators saying you can't impose arbitration on somebody. Whether arbitration is a good thing or a bad thing is sometimes in the eye of the beholder, but that's a trend that I think is worth watching. As far as the other problems in the industry, we mentioned transparency as a global umbrella issue across investors, borrowers, platforms, and the situations with Lending Club and whether that could have been solved by transparency. Who knows? But there certainly is, just like there is in the fund industry, a growing push for more and more and more transparency, and the people who do well with investors are the ones that act very transparently to their investors. And what does that mean? It's sometimes a buzzword without people understanding what it means. But it means disclosure and reporting and depth of detail available about your business, if you're the lending platform, to the investor. It means that the borrower underwriting criteria you use might have to be disclosed to the investor group. So there's a lot of people that don't want to do all that kind of disclosure, which puts you in the tension of being less transparent, which regulators, of course, don't appreciate.
And I do think the transparency analysis is a difficult one for some marketplace platforms to come to grips with. Yes, they publish an inordinate amount of data in their offerings, their registered offerings, but there is still an opacity about who the issuer is and whether or not the rates and the fees are, what they are, so that an investor knows what they're getting. I think that there is a concern with respect to further down the stream that securitizations really don't know what are in these asset pools, and it's reminiscent in many respects of the CDO market back in 2008, 2009. So I do think that there will be a move to more transparency, probably even standardization of some of these loans. But, the web is there, it's available. Everyone is fearful, however, that if information is put out on the web, that they're now engaging in an offering of a security, and that therefore that becomes evidence that the SEC will use to give them heartburn later on. So, at least in the whole loan space, there's this tension between security and non, and disclosure versus transparency versus a public offering. And so all of these issues need to be resolved. Until that happens, we're going to have investors sitting on their hands.
Agreed.
I wanted to thank all three of you for joining us today. For our listeners that are attending the Marketplace Lending Plus Investing Conference, please look for our podcast speakers at Booth 100 if you wanted to follow up on any parts of our discussion today. Thank you.